for reasons which have been explained, my Lord, in a plethora of authorities, and my Lord, permit me, as I conclude on that particular point, as far as the rationale is concerned for that particular decision, to refer you again to the Supreme Court decision of the Honorable Dr.Besigye Ssekukkulu and the 3 others versus the Attorney General and 4 others. It's Constitutional Application number 6 of 2013. Same year. Where the Supreme Court had the occasion to state, thus, it is the duty of the court to make such orders as will prevent the matter, if successful, from being nugatory, from being rendered nugatory. It's our contention, my Lord, that if you do not stay the proceedings, the constitutional matter would be rendered nugatory. And my Lord, my colleague, my Landy friend, Ernest Kalibala, has already succinctly explained that the gist of the constitutional petition, but for emphasis sake, my Lord, just for emphasis sake, that the right to a fair hearing under Article 28, which is non-derogable under Article 44, constitutes the thrust of the matter before the Constitutional Court. So if, my Lord, there is no stay, and it happens that the constitutional petition succeeds, my Lord, there will be a derogation from the right to a fair hearing, which would amount to an egregious abuse of Article 44 and 28. Most so, my Lord, when the constitutional petition touches the critical issue of the competence of this court in trying the accused persons. It's only fair and reasonable that, my Lord, this honorable court stays the proceedings, awaiting this decision of the Constitutional Court. Considering those imperatives, my Lord, which we have highlighted earlier on, raised in the recusal application, which are the thrust of the matter before the Constitutional Court. My Lord, on the second order sought, I would like to state, my Lord, that the two orders are inextricably intertwined. The two orders sought are inextricably intertwined. One follows the other. My Lord, once the proceedings are stayed, the next question is, what happens to the accused person's right to bail or liberty? First of all, there will be no order for their appearance before court again, because remand cannot be indefinite. I know one will contend that no, there will be mention. Even if that were to be the case, my Lord, that there will be mention of the case, the applicants or the accused persons will stay in Luzira as lodgers. Your brother, Justice Masaru Museveni, was once faced with that intricate and unique situation in the case of General David Sejusa Munungu versus Uganda. It's High Court Miscellaneous Application number 38 of 2016. Criminal Disciplinary Division, my Lord. I've got a copy, my Lord. My Lord, because of its significance and bearing on this matter, I will proceed to page 4 of this decision, my Lord.
Oh, it's a Supreme Court decision.
Where Justice Masaru Museveni posed a number of questions. Actually, there were 7, but I'll just read the 3 to guide the decision that he made, which with the present situation. Said, however, despite the suspension of the charges, the applicant is on remand and has been directed to apply for bail in the criminal division. Then he asked, this is rather a novel situation which has not arisen before, and there is no known laid down procedure to deal with it, or not rather with an application for bail where charges against the applicant have been suspended or stayed. The crucial question is therefore, does this court fold its hands and send back the applicant on remand in Luzira, and yet the charges over which he was remanded have been suspended or stayed? And if court is to fold its hands, won't that make the order of the High Court by Justice Ouma Oguri redundant? And finally, why should this court fold its hands and send back the applicant on remand, yet Article 139(1) of the Constitution, along with the Section 14 of the Judicature Act, grant the High Court unlimited original jurisdiction in all matters? He concluded by saying on page 5, in the present case, therefore, even if there is no appeal or reference from the General Court Martial, because the original matter was before the General Court Martial, in the present case, therefore, even if there is no appeal or reference from the General Court Martial, this court cannot fold its hands and chase away the applicant from the temple of justice. I shall exercise this court's powers under Article 139 of the Constitution and Section 39(2) of the Judicature Act to consider the bail application by the applicant. And he cited Section 39, which, my lord, under the revised edition, is Section 43 of the Judicature Act. Parimateria, my lord, that particular provision applies in the present circumstances. And the final decision he made, as I read, bearing in mind the law as outlined above, that is after citing the relevant provisions of the Judicature Act, the judge said, bearing in mind the law as outlined above, and in further considerations of Article 126(2)(e) of the Constitution, which empowers this court to administer substantive justice without undue regard to technicalities, I find and hold that the circumstances of this application warrant meritorious consideration. The offences with which the applicant is charged are bailable by this court, since the proceedings in the General Court Martial have been suspended pending the disposal. My lord, General Sejusa was accordingly granted bail, cash bail, actually on his own recognizance, much as I was a surety in this matter, as you will see, my lord, in this particular text. On his own recognizance, 10 million, not cash, just on his own recognizance, despite the gravity of the matter and the fact that it was before the General Court Martial. So, my lord, in this particular case, we have gone an extra mile of presenting substantial sureties, of bringing out the profile of the applicants, which are all comparing reasons, my lord, under the circumstances. But the crux of the matter, my lord, is not to leave the applicants as lodgers in Iruzira, because that was the issue here Justice Masaru Musene had to deal with. So once you have stayed the proceedings, it's axiomatic that the right to bail has to follow. My lord, we do pray that you be pleased to apply, rather to follow this very good precedent set by this very division to admit the applicants to bail after ordering the stay of the proceedings. We do so pray, my lord. And my lord, you don't have no idea as to when the Constitutional Court will dispose of the matter. You have no idea. It may take a year, it may take 2 years, or a month, and it's the reason, my lord, in Article 137, Clause 7, the framers of the Constitution made a command that proceedings be handled expeditiously, but we don't know as to when the matter will be disposed of, and that will be injurious to the rights of the applicants. We do so pray, my lord.
There are flight risks. I just want to comment that the bail, not the bail, but the application, the documents that annexed to the application, especially to the supplementary affidavit of A1, shows that he had previous cases of treason. This is not the first treason case. In both cases was admitted to bail. Yeah, thank you. And both cases he attended court as required until the prosecution either dropped the case until the conclusion of those cases, whatever the way. And therefore, he has no criminal record. None of them has a criminal record. And just to describe what advanced age means, It means anyone of 60 years and above. I therefore myself qualify as advanced age, and A1 qualifies as a person of advanced age. And A2 as well. So really, the court ought to be persuaded by this fact. Finally, and before I go to the final,
for record, I'm Richard Beautiful, Chief State Attorney. For the respondent. My Lord, the issues under business application number 814 should be, in our view, whether or not this court can stay proceedings before it, or proceedings under session case number 335 of 2025, and whether there are any remedies available, any other remedies available to the applicants. My Lord, the applicants filed this application premised on constitutional petition number 031 of 2025, which was annexed and marked B. My Lord, the applicants expect you to read that petition and assume that all the contents therein are true, which shouldn't be the case. Having filed constitutional petition number 0331 in the Constitutional Court, which we believe and agree with the defense or the applicants that it is higher than this court. They should have advanced these same arguments, presented these arguments, which unfortunately are not so convincing here, to the Constitutional Court. Because the Constitutional Court has control over that petition, which unfortunately this court doesn't. It will therefore be an act of insubordination. In fact, just to emphasize, for this court to think for the Constitutional Court. Because it is the Constitutional Court that has a duty to even think about the possibility of success of that petition. It's not this court. It is the Constitutional Court that can determine when the petition number 039, will be heard and completed. It's not this court. It is unfortunate that whereas that petition was filed against Attorney General, this application 03814 was filed against Uganda, DPP in particular. These are two different parties. It's just rational that the party who actually is part of the constitutional petition should be the same person who even argue the state. This court can only stay its proceedings if it has referred a certain matter or it has made a reference to the Constitutional Court. My Lord, if that was the case, then wouldn't be trying anyone. If that was the case, every person would be running to the Constitutional Court, file the petition, and then, if I'm quoting my senior brother, that to stay of execution, the stay of execution where there's a reference, where there's a constitutional petition, is a command. In fact, if that was the position, which unfortunately my senior colleagues misguided this court, then wouldn't be trying any person. Everybody would be finding a way of getting the Constitutional Court and avoid proceedings against them or trial. Whether or not even the applicants had made an application in the Constitutional Court, it is never a command, it is a discretion. My Lord, if you recall very well, this same application you recall very well, on the 6th of November 2025, but I can take you back to my Lord on the 1st of October. 1st of October 2025. There was an application for stay of proceedings. And on the 6th of November, this court dismissed that application. So this application, application number 814, is a replica of that application, my lord, that we invite this court to take judicial notice of, that was dismissed. The only difference is that by then, there was no constitutional petition. But my lord, the respondents are glad that counsel for the applicants took the guidance of prosecution, not the respondents, where we argued that they should have filed a constitutional petition in the Constitutional Court. We are glad. We appreciate that. But we still guide, my lord, that they should go to the Constitutional Court and file an application for stay of session case number 335 of 2025, but not in this court. This application is misplaced, and this application is an abuse of the legal process. And the purpose of it all, my lord, is to frustrate the trial. Completely to frustrate the trial. Allow me, my lord, just to give you a small background. On the 26th of August 2025, this matter appeared in this court for scheduling. And my lord, the accused persons never appeared in court on that day. However, prosecution was ready to proceed with the plea-taking and scheduling. Remember that day it's only the senior counsel of Angapu who appeared in court. On the 1st of September 2025, prosecution was ready to proceed with this case. However, it was only A3 who was in court. A1 and A2 did not appear in court. And on that day, my lord, the trial judge informed this court that A1 had written a note or a letter informing court that he was not well and therefore was unable to attend court. This background, my lord, is to show you how the defense or how the applicants are actually frustrating the trial of this matter using the weapons that are at their disposal, which include multiple applications. My lord, on the 1st of October 2025, as prosecution was ready to proceed with the scheduling and plea-taking, applicant number 1 suspended his lawyers temporarily and opted to speak for himself. which this court didn't allow, but directed that he writes all his concerns in a letter and file it by 3rd of October 2025. And that is when the court will respond to those, to the contents therein.